Okay, so welcome back all. Good evening to all, and here we are back on our new series of most important questions for UPSC 2024. So if you have seen our previous videos, we have started with polity and history. So since I am taking polity, in previous classes we have completed historical acts, preambles, features, then executive, parliament and legislature, and also the judiciary. So what we will do today is fundamental rights, and if possible we will try to complete fundamental duties and DPSP also. Okay, so as you all know that UPSC Prelims 2024 has been postponed due to Lok Sabha elections, so it will happen on 16th June now. Okay, so you have 22 days more, so that's a blessing for all of you. You can make use of it. So let us start. So starting with fundamental rights, this is the favorite topic of UPSC, if you all know, in mains as well as in prelims. So we need to be a bit more detailed on this topic. Okay, fundamental rights. Let us start. So fundamental rights can be studied under these heads. Okay, so we will go one by one and then we will solve few questions. That's it. As you know, this is a revision come most important question class. Okay, so you should have your notes with you. This is not an actual class, so you can take it as a revision class. Types of rights. So starting with types of rights, as you know, UPSC have been asking basic questions from fundamental rights and not the conventional ones. Okay, so you should know the conceptual part also. So what are the types of right? First is natural right, that means by birth. Then there are fundamental rights as defined in the constitution under part 3. Then those rights which are mentioned in constitution but not in part 3 are called as constitutional rights, that is rights other than part 3. Okay, so these are constitutional rights. So basically fundamental right is also constitutional right, no problem in it, but if you want to separate it, then fundamental rights will be part 3, constitutional rights other than part 3. And legal rights means by statute or by law, state law, parliamentary law, anything, that is a legal right. So legal right basically is a bigger circle. You can put all the constitutional fundamental rights into legal rights. For example, these may be fundamental rights, these may be constitutional rights. Okay, and these may be parliamentary law or state law. So all these are legal rights. Okay, so legal right is a big set. Fundamental rights, constitutional rights are the subsets. Okay, next. So there are few conceptual points that one should be clear of regarding fundamental rights. First is fundamental rights is called as Magna Carta of Constitution, or you can say the most important part. Okay, fundamental rights are for political democracy, while the DPSP, directive principles, are for socio-economic democracy. Okay, this fundamental rights are for political democracy, political advantage. Okay, original constitution at the time of start of constitution in 1950, we had 7 and not 6 as of now we have 6. Okay, so what is missing? Right to property is missing. We will see equality of status and opportunity. If you have read the preamble has this line as it is, and where it is suggested, article 14 to 18. Okay, then equality of thought, expression, belief. This can be interpreted from these articles 19 to 30. We will see articles one by one quickly in a short session. Okay, so these are equality of status, opportunity mentioned in preamble and here mentioned in article 14 to 18. Then liberty of thought, expression, belief from 19 to 30. Rights versus claims. This is an important debate. Basically, what are claims? We will claim on something. That claim that I can do this, I can do that. That is a claim. So basically all rights, if you say all rights are claims. Okay. So you are claiming something, right? Right to equality. You are claiming that all are equal. That's a right. So all rights are claims, but all claims are not rights. Okay, everything you claim cannot be a right. but all rights are the claims. But everything you claim will not be right. Only those claims will be right which are acceptable to the society. Okay. So all those claims which are acceptable to the society, accepted by everyone, that can be considered as right. So there may be a question in prelims that such statements may be given and you need to choose which one is correct, which one is wrong. So all rights are claims, but all claims are not rights. Okay. Further, rights are primarily claimed against state and sometimes against individuals. Yes, this is also correct. Generally, fundamental rights, if you say fundamental rights, these are the claims against the state. For example, a right to equality is violated, you will claim it against the state. Any right. But few rights are there that can be claimed against the individual. For example, right against untouchability. That is the absolute right. It can be claimed against state, can be claimed against individual. So right primarily are against state, but sometimes also against individual. There is one Supreme Court judgment also regarding this. We will talk it in the question. Applicable to only citizens. Okay. So fundamental rights, few of the fundamental rights are applicable only to the citizens of India, and majority of the fundamental rights are applicable to all the persons, irrespective of whether they being a citizen or not. So applicable to citizens, which are the rights? So Article 15, article against discrimination. 16, public employment. Then 19, right to freedom. 29 and 30, cultural and education rights. These 5 rights are only available for the citizens of India and not to any other person. All other rights are available for all the persons, not specifically citizens. Okay. So these are the rights. You should be knowing that they are only applicable to citizens. Then absolute nature of fundamental rights? No. Fundamental rights are not absolute rights. There are some conditions. For example, right to freedom is not absolutely freedom to all. Okay. That is John Harm's principle of J.S. Mills. We will study about that also. That right to freedom is not exactly an absolute right. Okay. There are some restrictions on it. For example, restriction with respect to security of the nation, with respect to defamation, with respect to public order, safety, health, etc. So there are not absolute rights, but few of the fundamental rights are absolute rights. For example, again, Article 17, untouchability. This is an absolute right. There is no constraint against it. It's an absolute right. Dice is rule of law. Another thing that we have gained from the UK Constitution. Fundamental rights we have adopted it from the US, but this Dice is rule of law. This we have adopted from UK. So what does this says? It says that first, that no person shall be punished for acts not violated. If he has not violated any law, okay, he shall not be punished. And if he has violated, then he shall be punished only after court trials. Okay, he should be tried before the court. Then only you can punish him. Second thing, what Dice's rule of law say, that all are equal, equality before law. Equality before law. That is mentioned in our Article 14. Third, it says supremacy of law. So first two statements, the punishment one and the second statement, equality before law, these two are applicable in Indian context, but the third, supremacy of law, according to Dice's rule of law, this is not applicable to India. This is applicable to only to UK. We have supremacy of constitution. We have supremacy of constitution, not law. Our constitution is supreme, parliament is not. So these are the few conceptual things regarding fundamental rights. Few more will come. We'll see we'll see in the questions also. Okay, so categories, we have already defined the categories of constitutional fundamental rights. We all know that. Right to equality 14 to 18, freedom 19 to 22, right against exploitation 23 to 24, right to religion 25 to 28, cultural education rights 29 30, and right to constitutional remedy 32. Okay. Now we'll just look on to each and every right in quick fashion. Not much time should be devoted to this because this is not an actual class. So you should be knowing all this. I'm just here to revise. Okay. So Article 12 gives the definition of the state. So what does it say? What does the state means? So Article 12 says any legislature, legislative body, local body, government body, parliament, state legislature, etc. all are considered as state. Even private organizations which are dealing in public duty. For example, government might have hired any private organization to do a public duty. For example, TCS, it is operating Passport Seva Kendra. So TCS in that case is a public authority. It will come under definition of a state. So these are the states. So what you need to know here, that what is not a state? Judiciary does not come in state. Supreme Court, High Court are not considered as state. Okay, so that's the thing you should know. Next, Article 13. What does Article 13 says? That laws passed in the parliament should not be violative of fundamental rights, and if any law coming from before the constitution has taken place, that law to the degree of the violation of fundamental rights shall be void. That is the second thing. Third thing, it gives the definition of law. Means, example, what is a law? Law can be a order, executive order, can be act, bill, not bill, act, then ordinance, etc. These are all laws, bylaws, etc. These are all laws. And what you can say, voidability of law. Article 13 talks about which law is void, which is not, with respect to fundamental rights. Any law which is interfering in our fundamental rights, that shall be void. Okay, so that is what Article 13 says. There are some amendments in Article 13. We will see that in next slide. So the thing you should know here is that definition of law. Law does not means a constitutional amendment. For example, if a constitutional amendment is made, Article 368 is made, then that is not a law. Okay, this is a Supreme Court judgment. We will see this again further. Equality before law and equal protection of law under Article 14. Now you should know equality before law and equal protection of law. These are two different terms. Equality before law, this come from UK. These concepts come from US. Okay, so equality before law means everyone is equal before law, whether he be a minister or a watchman. If both of them have committed a crime, they shall be equally punished. That is equality before law. Equal protection of law means persons are, for example, in case of civil laws, taxation laws. Now person committing any crime in taxation law, who has salary above 30 lakhs will fall in a different bracket, who has salary below 10 lakhs will fall in a different bracket, so they are to be treated differently. But that is equal protection of law. Okay, so with respect to their respective position. Okay, so that is the equal protection of law. So this is a negative concept, everyone is equal, and this is a positive concept. Okay, so that's one we have got it from US, and equality before law we have managed it from UK. So you can say this as equal treatment under equal circumstances. For example, tax. For example, military. There are different laws for common people and different laws for military. So that is equal protection law, because their condition is different, their circumstances are different. So that is different. And equality for law means completely everyone is equal. Okay, so that is a negative concept, that's a positive concept. So these are the things. So the currently in news Constitutional Amendment Act, which the current dispensation has passed, is under scrutiny for violation of Article 14, arguably for the violation of Article 14. But since Supreme Court has already said that it's not that it's unconstitutional, we have said that it is not unconstitutional. Okay, so Article 14, there is some problem with the Constitutional Amendment Act. We can debate on it. Okay, for example, Constitutional Amendment Act specifies 6 religions, okay, from 3 different states, 3 different countries. So what it violates is equality before law. You are not treating everyone equally, but that's a different debate. Article 15, no discrimination against. So this is an anti-discrimination article. So what does Article 15 says? For example, 15(1), there shall be no discrimination against race, religion, caste, sex, place of birth. Okay, you cannot discriminate anyone on these grounds. Second, same thing, no discrimination in entry to any public places or etc. That is not important. Third, 15.2, 15.3, state can give certain preferences to women and children. Okay, certain specific provisions can be made for women and children. That's one thing. Then 15.4 deals with, again, state can, irrespective of that, state can give certain provisions for economically backward sections. Okay, for example, SC, ST, OBC. Okay, so backward section, state can give certain provisions. For example, this is an article for reservation. This was not in the original constitution. This came in Constitutional Amendment Act of 1951. That is first Constitutional Amendment Act. We got this. We will see this in DPSP. We will come back to this again. 15.4 done. 15.5. 15.5 again it's an extension of this act only. That is, no children can be children shall be available for education in all the institutions. Means reservation for students in education institution. Okay, that's what 15.5 says. All SC, ST, OBC shall have certain reservation in even in private education institutions. Okay, except in minority institutions. So this act does not apply to minority institution. That will come under Article 31. We will see Article 31. We will come back to it. 15.6. This is for reservation for economically weaker section. This again was not in the original constitution. This came in 103rd amendment. 103rd, yes. Okay, 103rd amendment. So this is about Article 15. Then comes Article 16. This is about public employment. Equality. So this must be a printing mistake. You should not read this. Equality of status and opportunity. Equality of opportunity. So 16.1 actually says this only. 16.1, this is equality of opportunity. 16.2, no person shall be discriminated for any public office on the basis of what? On the basis of everything that is written in Article 15, race, religion, caste, sex, place of birth, and there are two more conditions here. Shall not be discriminated on descent and place of residence. These are the two extra conditions added in this act. Then 16.3. 16.3 says that Parliament can make residence applicable. Okay, Parliament can in its own jurisdiction can make residence compulsory for a particular government job. 16.4. This is again reservation in government jobs for SC, ST, OBC. For SC, ST for reservation in government jobs. 16.4a. This was added in the 77th Amendment Act. 77th Amendment Act, 16.4a. Reservation in promotion. Reservation in promotion for SC, ST. Okay. For SC, ST. Then 16.4b. Now you know there is a limit for reservation in every state. For example, it shall not go beyond 50% according to Indira Sahani case 1992. So 4b says that while calculating that ceiling limit, if there are any vacant seats available from the previous year, you should not calculate it under this year. Okay. So basically whatever is left from 16.4, 16.4a shall not be included in the next year if they are vacant from the previous year in calculation of the ceiling. Okay, so that's the 16.4b. Then comes 16.5. 16.5 deals with the applicability of any religious person which is needed to be over a institution, religious institution. So state cannot do anything about it. That's not important. 16.6 again reservation for EWS. That's again 103rd Amendment Act, EWS. Okay. You should know each and every article in under fundamental rights. Okay, by heart. You should have a constitutional bare act with you. Try to read the language in the constitution of each and every act. Fundamental rights, DPSP, and fundamental duties. Direct questions are being asked from this right directly. They are copying and pasting it the paper from the constitution itself. So you should know. Article 17, as I have already told you, It's against untouchability. This is an absolute. This is the one of the absolute act. There is no restriction on this act. Okay, absolute. It can be against person also, against individual also, not only against state. Okay, so this is one. Article 18 regarding titles. As you are aware of, no citizen of India shall be awarded any title. Government should not give any title to any citizens of India. Then if a person who is not a citizen of India but working under government of India shall not take any title from any other state without permission of the president. And last one is that no person or citizen shall take any office from any other country without permission of the president, or any gift also. So that's not important. Article 18 you can read by yourself. Article 19, freedom, right to freedom. Now right to freedom, there are some conceptual things here. For example, first comes, what is a liberty? So the liberty, if you know, freedom, liberty, we use them interchangeably, but liberty can be categorized into two parts: positive liberty and negative liberty. What is negative liberty? Negative liberty, you can say you are restricting state. Okay, that is liberty from. You can say liberty from, and this positive liberty means liberty to, means you, how can you develop? Okay, that's positive liberty. If state is giving you incentives to do something in your life, that's called as positive liberty. You are by freedom able to do anything without harming others, is called as positive liberty. That's a liberty to, and this is liberty from the state. There are restrictions on state. Restrictions on state. Okay, so this is a negative liberty, this is a positive liberty. This is regarding our development, this is regarding restriction on the state. Okay, so that's a negative liberty, that's a positive liberty. Most of them are negative type. Okay, most of the article 19 we see are negative type, restrictive type. Positive liberty we will see in DPSP more. Okay, then there is a J.S. Mill's Harms principle, which talks about self regarding principle, others regarding principle. Same thing here. If it is a self regarding principle, for example, liberty, positive, we are talking positive liberty, development of oneself, we are talking about ourself, then state should not intervene. State shall not intervene. Okay, so this is more of a positive liberty. Okay, so state shall not intervene if a principle of freedom is regarding self. If there is others regarding principle, for example, if our liberty is harming some other person, then that's a others regarding principle, then state can intervene. Okay, so then state can intervene. Okay, so these are the self regarding principles, other regarding principle where state can intervene. Self regarding principle, state will not intervene. Negative liberty, state has to intervene. State restrictions on state, and positive liberty, our own liberty to do anything, that's called as positive liberty. That is freedom to. This is freedom from. I am again writing freedom from something. This is called as liberty. Freedom from, you put it in a sentence, you will get it. Negative liberty means freedom from something. Positive liberty means freedom to do something. Okay, so that's the difference. Further, now 19F. Now if I go on listing the articles here, 19A talks about freedom of speech and expression. 19B talks about freedom of assembly. 19C talks about freedom of forming unions, cooperatives. 19D talks about you can roam in any part of the country. 19E talks about you can settle in any part of the country. 19F, this was right to property. This was removed, as you know, from 44th Amendment Act, removed this right. Now we don't have this, but we have the next one, that is 19G, which is to carry on any businesses as we like. Okay, so that's, but there are some restrictions on this act. Okay, for example, 19.1a, there are restrictions mentioned in 19.2. What restrictions are mentioned here? For example, freedom to speech and expression are subjected to following things. What are the following things? Subjected to what? Security of the nation, public order, health, morality, decency, friendly relations with other nations. Then what are the other things which are restricting our right to freedom and speech is defamation, incitement of violence. These are restricting our fundamental right to speech and expression. That's why I said you that fundamental rights are not absolute right. There are some restrictions. Similar restrictions are available for this. You need to check it in your constitution. Then move further. Article 20, protection with respect of conviction of offences. So this is one important thing here. Article 20 deals with conviction of offences. If an offence has been proved and the person is convicted, then what happens? So first is that there shall be no retrospective action. Means a crime committed in, for example, a thing which you take example of murder. If a murder is committed in 2015, okay, but if murder was not a crime in 2015, it became crime in 2018, okay, then a government cannot bring a law saying that okay, now murder is illegal, but it shall be applicable to 2015 also. So that person who committed a crime there which was not crime at that time shall also be convicted. So that should not happen. So no retrospective action, means backdated action cannot be taken. But this is applicable only to criminal cases, okay, only to criminal cases. Retrospective actions can be taken place, can be done in regards to civil laws or preventive detention, okay. So no retrospective action only for criminal cases, only for criminal offences, not for civil or preventive detention. The retrospective action can be taken against civil or preventive detention. Then comes self-incrimination. Self-incrimination means witness in his own case. Witness in his own case. Again, you cannot be witness in your own case. Again, this is applicable only to what? Only to civil cases. Now this is applicable only to witness against his own. You cannot witness in your own case. That's the thing with self-incrimination. Again, this is only applicable to criminal proceedings, not to civil. Only for criminal proceedings. If there is a civil case, if you have done any crime regarding taxation law, then you can be witness in your own case. No double jeopardy, means you cannot be punished twice for the same action, okay. For the same crime you cannot be punished twice. Again, this is applicable only to judiciary. For example, a court cannot punish anyone twice for the same action. But for example, a person who is a government servant in certain public authority, now he has done something wrong in his office, then court has given him some punishment. The public authority can give him the punishment for the same action, okay. So that is possible, but judiciary itself cannot jeopardize it twice, cannot punish it twice, but a public authority can. Okay, so that's the thing with Article 20. Then comes right to life. Very celebrated right is right to life. Every now and then there are some rights which comes under right to life and liberty, okay. For example, recently right to privacy was included in right to life. But there are certain principles here that we should know against right to life. There is one called as due process of law and another called as procedure established by law, okay. So talking about due process of law, for example, in Indian cases we will see judiciary how it works. There is due process of law and there is procedure established by law. Again, this is coming from US, this is coming from UK. What we have been following is this, okay, we have been following this. So what is the difference? Difference is that in procedure established by law, for example, you need to check if any right is violated. For example, right to life is violated against a certain thing, okay. So if if there is certain thing that a state does and you think that it is violating your right to life. For example, right to privacy is only violated because right to privacy is under right to life. If your privacy is violated because of some action taken by government, okay. For example, you can say about the recent decision of the Supreme Court regarding electoral bonds. Now, the electoral bonds, that act was introduced by taking confidence the corporates that their names will not be disclosed. So, there were few applications from the corporates that our right to privacy has been harmed here, but Supreme Court has not bent down to it and it has said it is unconstitutional. So, matter of the fact is that, for example, we are taking right to privacy. If it is violated due to any government law, okay, then, and if a person goes to Supreme Court that my right to privacy is violated. So, what Supreme Court will act on is that Supreme Court will check, in this case, I am talking about this case, Supreme Court will check if the procedure of creating that law, application of that law is followed or not. If the procedure is clearly followed, according to the law, everything is done according to law, procedure clearly followed, then that person cannot claim that his right to life is violated, okay. So, if the procedure is correct, everything is correct. That was the thing of procedure established by law. For example, we have a case here called as A.K. Gopalan case. A.K. Gopalan case, Supreme Court clearly said that protection under Article 21, protection under Article 21 is available only against arbitrary executive order and not against arbitrary law. So, what it says that executive order, okay, if by executive order your right to life is if your right to life is violated, then okay, fine, then it can be carried on. But if a parliamentary law is passed and its procedure is correct, then you cannot claim against that law. So, what it says, Article 21 is available only against arbitrary executive action, not against arbitrary legislative action. So, legislative action can be arbitrary, but if procedure is followed, then everything is right. Your right is not violated. That's what A.K. Gopalan's case said. Then again, one another case was there. If I may write here only. Again, one another case was there in case of Menka Gandhi case. Supreme Court in case of Menka Gandhi case. Menka Gandhi case, you need not to go in detail of the case, just know what Supreme Court said. Supreme Court says that now protection under 21, protection under Article 21 is available against, of course, against arbitrary action of the executive, but also against arbitrary legislation. Okay, so what does this say? Protection under 21 is available against executive order and also against arbitrary legislative action also. Okay, so now only the procedure thing will not be checked. Okay, so the base behind it will also be checked. For example, here it says that Article 21 should be checked along with Article 19. You should overlap it and then check. So basically, now what Supreme Court is saying that Article 21, you should, while application of Article 29, for procedure established by law. Now the new thing has come, procedure established by law, which is reasonable. Okay, means there are some restrictions to it also. This procedure established by law which is reasonable. For example, Article 21 should be looked in with Article 19, right to freedom. There should be an overlap in it. Okay, so procedure established by law which is reasonable. That is the present condition for application of Article 21. So this is also called as due process of law. Okay, so India have now shifted from procedure established by law to due process of law. Now only arbitrary legislative action will also be checked for reasonability. Okay, so that's the thing. So those were the two Supreme Court cases. One was A.K. Gopalan case and the other one was Menka Gandhi case. So current situation is that Supreme Court follows procedure established by law which is reasonable. That is due process of law. Further, Article 22, protections against arrest and detention. So, protection against arrest and detention in this article there is not much. It just says that you should give reason for arrest of any person as soon as possible. There is no time limit given when to give that information, why you are arresting him. Then another thing is that you should present that person who you have arrested in 24 hours in front of judicial magistrate, okay, district magistrate, within 24 hours. But these rights are not available for enemy aliens, not available for enemy aliens, and neither for preventive detention, only for normal detention. So that's it. Okay, so what we are missing here is Article 21A. So this was not in the original constitution. It was introduced by 86th Constitutional Amendment Act. Okay, that was right to education. Okay, right to education. Basically, free and fair right to education for 6 to 14 years. Compulsory education for 6 to 14 years, that shall be free. So that is 21A. We have seen 22. 23, prohibition of traffic and forced labor. You cannot force anyone into any compulsory action. Okay, compulsory forced labor you cannot do it. This is also right. There are certain exceptions here. For example, government service, military service, that is exempted from this act. Then 24, prohibition of child labor act, prohibition of child labor. Now constitution, prohibition of child labor. In constitution, it is only written that children less than 14 years shall not be employed in hazardous activity. Okay, so children less than 14 years shall not be involved in hazardous activity. That's all written in the constitution. But then we have Child Labor Act of 1986, which says that actually it was for implementation of Article 14. Okay, because constitution only mentions children less than 14 shall not be employed in hazardous activity. Then this new act came. This says children under Article 14, children under the age of 14 years shall not be employed anywhere except for family run enterprises or for art. Okay, but children 14 to 18 years, they shall not be employed in hazardous conditions. Okay, so they have improved the statement which is given in constitution. What they say, the act says less than 14 years no employment, 14 to 18 years no employment in hazardous situation. Next, freedom of religion. We are talking about Article 25, freedom of religion. Again, it is subjected to what? Public order, health and morality. So if you say Article 25, you know, right to religion, you can profess your religion, you can promote your religion, etc. with subject to public order, health and morality. So this is a individual freedom of religion. Article 25 deals with individual freedom of religion. Then another thing in Article 25 is that state can interfere in every non-religious activity with respect to religion. Okay. 26th, this freedom of religion of group. Now this was for individual, this is for 26th article is for group, freedom of religion of group. For example, they can with respect to subject to the same. Okay, restrictions on 25 and 26 both are same, public order, health and morality. There are restrictions. Freedom of religion, you know, freedom of religious in group. Okay, so this was for individual, this is for group. They can own and acquire any property, they can manage their own religious affairs. Those are few things given in Article 26. Article 27, if there are any proceeds with respect to religion, they shall not be taxed if it is for promotion of religion. Okay, that's another thing. For example, cases with respect to right to religion is triple talaq and Shabarimala case. Shabarimala case, it was a temple in Kerala. The government made a law that women of a particular age cannot enter in this temple. Okay, but Supreme Court, 5 judge bench of Supreme Court said that it is unconstitutional, it is against Article 14, right to equality. Even few judges went on to show that it is against Article 17, untouchability. Okay, but now the case is under 7 judge bench. We will see what happens. Triple talaq case, again talaq-e-biddat was nullified by the Supreme Court as it was against Article 25. Further, Article 28 religious instructions. Regarding religious instructions, there are three parts in Article 28. First, if an institution, so Article 28 talks about religious instructions in school, in education, okay, in an institution. If an institution is completely aided by, fully aided by state, then no religious instructions are allowed, okay. If it is fully aided by state, no religious instructions. If it is only administered by state but maintained by a trust who requires that religious instructions need to be given, then religious instruction can be given, no problem. Third is that if it is recognized by the state and there is some aid from the state, okay, some aid from the state to that institution, then it is not compulsory. You can give religious instructions in such cases, but it is not compulsory to sit in that religious instructions, okay. It's not compulsory. You should give your accent to it, or if you are not adult, then your guardian should give accent to it, okay. So compulsory sitting in religious instruction class is not required if there is some kind of aid from the state, okay. If this is fully aided by the state, no religious instruction can be given. Then comes Article 29 and 30. These are cultural education rights. For example, Article 29, we can say, if there is a endangered language or a script or anything which we think that it shall be protected, it can be protected under Article 29, okay. So though it is mentioned minority, this Article 29 is not only applicable to minority, okay. A majority group can also claim Article 29. For example, there is a majority group and they have some certain kind of script which is getting endangered, they can raise their issue under Article 29, okay. So it is not only for minority, but Article 30, this is completely for minority education, okay. This is not for any other class, this is only for minority. Definition of minority is not given anywhere in the constitution, it is given in Minorities Rights Act, okay. That's a different, it is given in okay, it is not given in constitution, I will check where it is given. 30, Article 30 says religious minority religion can start their own educational institution and then can run as per their requirements, okay. State cannot interfere in the religious matter in that particular institution. Then further, Article 30, okay, so that's all regarding Article 30. Even state can intervene only in secular decisions there, not in any other else. Then Article 31, right to property, this was removed, as you all know. 32, Article 32 means constitutional remedy against your violation of rights under fundamental right, okay. You can directly go to Supreme Court. Now Supreme Court, if you go to Supreme Court in violation of your fundamental rights, Supreme Court has the power to issue writs, that is writs, okay. So that is nothing but Article 32. It's your fundamental right to go to Supreme Court, and Supreme Court cannot say no. That's why Supreme Court is called as guarantor of the fundamental right. So there are few writs. For example, writ 1 is habeas corpus, which means show the body of, okay. If he is illegally detained, if a person is illegally detained, and you can go in Supreme Court and ask for habeas corpus petition, and court will ask them to show up in the court, okay, if it is illegally detained. That is called as habeas corpus. This writ can be issued against whom? That's what we are talking about. This can be issued against private individual or organization, and even against public authority. For example, police. This can be issued against public authority. Then mandamus means Supreme Court can give instruction to a lower institution or court to do something, okay, to do something. Directly it is asking to do something. So this mandamus can be issued against whom? Against almost everyone. For example, private individual, for example, public authority, legislature, judiciary, quasi-judiciary bodies, but not against private individuals. Not against private individuals. Supreme Court cannot give instruction to do something to a private individual. Okay. Other than thing, you can safely assume that everything can fall under this. So mandamus can be issued against almost everyone except for private individual. Prohibition means Supreme Court shall order that to stop something, okay, or to prohibit certain order. This order can be given only to judicial and quasi-judicial authority. Okay, to not anyone else, only to judicial, quasi-judicial authority. Certiorari, this means Supreme Court may quash order. Okay, any order is given from the lower court, it may completely squash that order or ask that lower court to file the case in the upper court. Okay, for example, appeal. So this can be done against judicial, quasi-judicial as well as public authority. Okay, these three things, certiorari can be issued against these three, and quo warranto can be issued against a person who is illegally sitting in a position of a power. Okay, for example, he is not eligible for a position of a CM and he is a CM. So in such cases, quo warranto can be issued. For example, this was issued against Madam Jayalalitha in Tamil Nadu few years back. Okay, now you can say mandamus to Supreme Court is asking lower thing to do something. So this is a preventive. Prohibition, this is also preventive mechanism. Certiorari can be preventive, for example appeal, or can be reactive also. Okay, so that we all don't know here. In these cases, yeah, that's all we should know about the writs. One thing you need to know about writs is that who can issue writs. So under Article 32, we have fundamental right to go to Supreme Court in case of violation of our fundamental rights, and Supreme Court cannot say no. But you can also go to High Court under Article 226, okay, in case of violation of fundamental right. But it is up to discretion of High Court to take that case or not. Okay. So here Supreme Court has writ jurisdiction only for writ jurisdiction. That means it can issue writs only for fundamental rights, but High Court can issue writs for fundamental rights as well as other rights in the Constitution, as well as other rights. So you can safely assume that writ jurisdiction of a High Court is wider than writ jurisdiction of the Supreme Court. This we have seen in the judiciary also. So that's the thing here. Okay, now we will see the amendability. How the Constitution fundamental rights amendment procedure has been evolved from the start of the Constitution. Okay, we will quickly see it and then we will move on to the questions. So there was first constitutional amendment was acted. Article 31A was enacted. Okay, so basically that article was that regarding compensation of land. For example, if a government want to acquire some certain land from certain individual, they have to previous to this amendment they have to give it at a market rate. Okay, but after this 31A, this is regarding to property. So now what government can do, they can acquire any land without any compensation or compensation which is less than market value. Okay, you can simply assume that because the language is written in the Article 31A is a bit difficult. You can safely assume that now the right to property is not absolute right. Now government can take your land by arbitrary legislative action. Okay, so government can take your land and may not give you the market value of that land. So with respect to this, so there were many land issues rose in that era. Okay, so the first case that arose was Shankari Prasad versus Union of India. Now obviously his land was taken by the government and he went to the Supreme Court asking that his fundamental right, which was 19F at that time, because 19F was not removed until 1978, 44th Amendment Act, 19F was removed. Till that time 19F was there, that is right to property was a fundamental right, fundamental right under right to freedom. Okay, so Shankari Prasad went to Supreme Court asking his 31A violated his right of 19F, that is right to property. What Supreme Court said? Supreme Court said that this 31A is brought from constitutional amendment. So constitutional amendment is not a law. Now if you remember what is said in Article 13, Article 13 give definition of law. Now that what is law is maintained in Article 13, law, bylaw, executive order, etc., etc., but there is nowhere mention of constitutional amendment. So what Shankari Prasad versus Union Supreme Court said that constitutional amendment is not a law, so Supreme Court cannot do anything. Okay, so constitution can fully be amended by Parliament. There is no role of Supreme Court. That's what Shankari Prasad versus Union of India said. If a constitutional amendment is passed, Supreme Court cannot do anything because it is not a law. So what Supreme Court can do? So basically he made Parliament supreme. Parliamentary supremacy was, you can say safely that it was a parliamentary supremacy. Parliament can amend any article of the Constitution. So that was the first case. Then comes the next case. Okay. So Shankari Prasad versus Union of India, Supreme Court said constitutional amendment is not a law. So Parliament can amend fundamental rights, any law of Constitution. Supreme Court cannot do anything. Then similar case, Golaknath case was followed. This was same regarding the right to property itself. Okay. He was a farmer in, I think, Punjab. His property was taken by the government and he went to Supreme Court against the same. Now Supreme Court overturned the decision. Okay, Supreme Court said Constitutional Amendment Act is a law under Article 13. Under Article 13, Constitutional Amendment is a law. And again, Supreme Court added one more thing: fundamental rights are sacrosanct. Means you cannot touch fundamental rights. You can amend any article other than fundamental rights. Okay, so Parliament have supremacy over Constitution other than the fundamental rights. Parliament can amend any article beyond the fundamental rights, but not the fundamental rights. You cannot touch fundamental rights. Okay, and Constitutional Amendment is a law. That was the order given by Golaknath case in Supreme Court. As soon as the Golaknath case was done, there was a 24th Amendment Act which followed the Constitution. Okay, as soon as the Golaknath case was done, Parliament came up with 24th Constitutional Amendment Act. What it said? It said that it added Article 13(4) and said constitutional amendment is not a law. Constitutional amendment under Article 368 is not a law. Okay, this is what the 24th Amendment Act said. And further, it also said that if any, okay, we will not go in that detail, but it said that constitutional amendment is not a law. Keshav Bharati case, then again similar case was raised in Supreme Court. Now Supreme Court overturned the Golaknath case. Okay, now here Supreme Court said, okay, Constitutional Amendment Act is not a law. Okay, so basically it upheld this 24th Amendment Act. It upheld this 24th Amendment Act. It said that okay, it is not a law, but then comes a new thing that is called as doctrine of basic structure. There are few things in the Constitution which are basic structure of the Constitution. Parliament cannot touch them. Okay, cannot amend them. So basically, other than basic structure, Parliament can amend fundamental right, can amend any act of the Parliament, but not the basic structure. Okay, and basic structure, time to time, judiciary, Supreme Court has given examples of basic structure. For example, federalism, secularism, etc. are the doctrine of the basic structure. So this is how we came to basic structure. Now after this also, Indira Gandhi government then came up with a new thing, 42nd Amendment Act, and it said that Parliament has every right to amend everything in the Constitution. But that was again challenged in court, and Minerva Mills case again cancelled it out, and we are stick to this position now. That now the position is that what you need to know, constitutional amendment is not a law under Article 13. Okay, is not a law under Article 13, and 24th Amendment Act is upheld by the Supreme Court. and there is a new doctrine called as basic structure doctrine, that basic structure cannot be amended. That's all. Okay. Then first constitutional amendment, if you want few more information, 15.4 I have already told you was added in first constitutional amendment. 31A, 31B. 31B is nothing but 9th schedule. Means if any act introduced by parliament or state, if it is placed in article 9th schedule, it required a constitutional amendment. Now already court had said constitutional amendment is not a law, so it will not go into judicial review. That was the idea behind 31B. But now since judicial review itself has become basic structure, this thing is now redundant. That is not much of use now. 24th Amendment Act, okay, we have already talked about. 25th Amendment we will talk in DPSP. Okay, so now we will go to questions. Okay, there is one more thing that you should know, that as it is in current condition, Article 16. Sorry for this printing mistake. Equality of opportunity in public government offices. Now there was Indira Sahani case regarding this Article 16 public employment. First you should know about the Mandal Commission, which was implemented by government of VP Singh. Okay, so what it said? It said that there shall be reservation. Before 1992 there was no reservation for OBCs, right? After 1992, now reservation in public office. Reservation in public office. So 27% reservation is for OBC, 22% is for SC ST. Okay, and remaining 50% is general category. This is the scheme of the things now. Now against this thing, there are few states which have crossed this limit. Okay, means what we can interpret from this, that there should be 50% limit, at least 50% limit, okay, in the reservation. Then a case came known as Indira Sahani case. Indira Sahani case, Supreme Court said that there shall be limit to reservation, and that limit shall be 50%, and this shall not be breached. This shall not be breached except in certain extreme situation. For example, community is not at all represented in, or very less represented in the public offices, then you can increase this limit 50%. But you have to give strong reason to increase this reservation limit above 50%. Means you cannot extend this reservation OBC, SC, ST, then there is EWS also beyond 50%. Okay, this shall not be breached. This was Indira Sahani's case. Now you should know about you might be knowing about the Maratha reservation issue going on in Maharashtra. Now what Maratha issue is that they are asking for reservation for Maratha in public offices under Article 16. But currently Maratha operates under open category, means general category. So they are asking for reservation. Now problem is that if there are two ways why Maratha can be given reservation. For example, Maratha reservation. So there are two ways. One, now there is constraint put by Indira Sahani case that 50% limit should not cross, should be kept. Okay, so we have already seen 22% ST and SC reservation and 27% OBC reservation. So this is the present situation. So one way is that include all the Maratha in OBC. Include all Maratha in OBC. So OBC plus Maratha will get 27% reservation. This is one way. Another way is that 22% SC ST, 27% OBC plus some more percent to exclusively Maratha. For example, let's say 10% to Marathas. This is another way of giving reservation. But problem is that this is crossing the 50% limit. Now this was already done by previous government and it did not stood the test in Supreme Court. Supreme Court said that we cannot extend beyond 50% because you don't have any proof to show that Marathas are not represented in public office. So state government lost that case. and we are back to square one. Now what the situation is that the Maratha aditants want the government to include Maratha under OBC reservation. So the 27% will be included for OBC and Maratha. This is the demand from Maratha community. So let us see where the decision goes, but that's the context. Okay, so you should know. May not be important for prelims, but must be, you can include it in a mains answer also. Okay, so we'll now go to questions. Consider the following statements regarding Article 14. The Indian Constitution under Article 14 provides only for equality before law and not equal protection of laws. So this is completely wrong statement. It also provides for equal protection of law. As per Supreme Court, where equals and unequals are treated differently, Article 14 does not apply. Yes. So for example, Article 16(4), which talks about reservation to particular category. Now you can safely say that reservation to particular person is violative of Article 14, equality before law. But the problem is that reservation is we can say it's a positive step for historical wrongs to certain communities. That's why reservation is given. So those are not equals. For example, if unreserved community is somewhere here in the paradigm, the reserved community, for example SC, ST, are somewhere here. These are unequal. The open category, for example, it is already at certain level, but the education income level for SC, ST is down. So these are unequal. Okay, unequal levels. So Supreme Court in one of its case said that if equals and unequals are treated differently, Article 14 does not apply. That means when reservation is given, then Article 14 will not be applicable. So this is also right. This is wrong. Only 2 is correct. Which of the following provisions are fundamental duties under Article 4? Okay, fundamental duties question came here. Okay, we didn't talk about fundamental duties, but still we will talk it in the next class. To abide by constitution, respects its ideals. Yes, this is included in fundamental duties. To protect, improve the rivers and wildlife. This is also included. Equal justice, welfare of the people. This is also included. To promote spirit of common brotherhood. This is also included. Okay. Okay, so this is included in DPSP. This is not in fundamental duties. Go and check every fundamental duty. The language of every fundamental duty is hardly 1 page. Okay, we will see fundamental duties in later class. Article 19, right to form cooperative societies under Article 19 is added by the way of constitutional amendment. Now, I have told you 19C. 19A is right to expression, freedom of expression. B is assembly, right to assemble without arms. 19C, we talk about 19C. This give you right to form union, right to form association. Okay, so this was in original constitution. Then there are constitutional amendment made, and one more thing added here was cooperative societies. Okay, so the fundamental right to form cooperative society is coming under Article 19C, and this is by Constitutional Amendment Act, which was 97th Constitutional Amendment Act. Okay, so this is right to form cooperative societies under Article 19 is added by the way of constitutional amendment. Rights under this article are not available to legal persons like companies. Okay. So what is saying, right under this article are not available to legal persons like companies. Means under this article, Article 19. So initially, fundamental rights, there are few fundamental rights which are applicable not only for citizens but for persons, but also for legal persons. What do you mean by legal persons? Legal persons means companies, institutions. Okay, companies, institutions, etc. We can call it as a legal person. So what it says, Article 19 are not available to legal persons like companies. So this is correct statement. Article 19 does not apply to legal persons like companies. It is only applicable to citizens. This is correct. Okay. One more thing, what is given here? Now this is more related to recent judgment of a Supreme Court. Only vertical application of Article 19 is possible in case of India. So vertical application means this is only applicable against state. For example, Article 19, if it is violated, action can only taken against state, not against private individual. Okay, that's what vertical application says. Only against state. You can claim the right Article 19, right in Article 19 only against state. That is called as vertical application. Then there is term of horizontal application. Horizontal application means now in case of violation of your Article 19, it can be claimed against private individual also. Okay, also against private individuals, not only against state. So this was recent judgment of Supreme Court. It said that Article 19 can be applicable against state as well as private individuals, means vertical application also and horizontal application also. Before this judgment, it was only applicable against the state. Now it is available against private individuals also. Okay, so this is wrong. Citizen declare renunciation of citizenship. Okay, an Indian citizen has declared renunciation of his citizenship in 2015 when his son was 10 years old. Okay, subsequently his declaration of renunciation was successfully registered. Which of the following fundamental rights which will be enjoyed by his son today? Now this is a combination of fundamental rights applicability to citizens and non-citizens plus citizenship. So whenever a person renunciation of citizenship is done, automatically his dependents which are less than 18 years old will automatically lose the citizenship. Okay, so basically in this case son was 10 years old, so his son has also lost the citizenship. Now we need to check which fundamental rights will be enjoyed by his son, means who is not a citizen of India, basically any person. So we need to check these fundamental rights which shall be applicable only to all the persons and not only to citizens. Okay, so which of the rights are available to all the persons? I have already told you. Citizens, if citizens 15, 16, 19, 29, 30, these are the applicable only to citizens. Other than these rights, every right is applicable to all the persons. For example, right to privacy, this is 21. Protection against arrest, detention, this is 22. Right to freedom of speech, expression, this is 19. So if the son is not a citizen, then right to privacy is applicable, protection against arrest, detention is applicable, but Article 19, this is not applicable. Fundamental rights. Okay, these rights are sacrosanct and are available only to citizens. I have already told you there are a few rights which are available only to citizens, but there are majority rights which are applicable to all the persons. So this is wrong. The rights lay limitations on the authority of the state and hence negative in character. Now that was the definition of negative liberty. I have told you that there are the limitations on the authority of the state. So that limitations means negative character. Hence this is correct. The aim at establishing a government of men and not of laws. This is also correct. Establishment of government of men and not of laws. Okay. If it was government of laws, then it should not have been a negative character. Okay, so they aim at establishing a government of men and not laws. This is also correct. They are justicable. Of course, they are justicable under Article 32. Most of them are automatically applicable. Okay, no need to go in court. So 3 statements are correct. Statement 1: Parliament and legislature of a state can make laws prescribing residence as a condition for certain employees. Now this is regarding public employment. Okay, this act is regarding public employment. 16, Article 16. Now what is the condition for prescribing residence? Now I already told you 16 article deals with no discrimination with respect to race, religion, caste, sex, place of birth, place of residence and descent. So this is talking about place of residence. Now who can decide if the place of residence should be condition for a public authority? Only the parliament, not the state legislature. clearly mentioned in Article 16(3), which mentions that only Parliament can make law prescribing residence as a condition for certain employment in state and union territory, not the state. So this part is wrong. So this statement goes wrong. Automatically answer will be D. Let us see what is the second statement. Parliament alone has the power to prescribe laws restricting or abrogating the application of fundamental rights to members of armed forces. Yes, this is right. The Constitution ensures for all citizens of India equality of status and opportunity. Now again, equality of status and opportunity. This is regarding Article 16. Article 16, is it applicable for all citizens? Yes, it is not applicable to the persons, but applicable for all citizens. So Constitution ensures for all the citizens of India equality of status and opportunity. This is actually mentioned in the preamble, this same line, equality of status and opportunity. Sorry. Yes. Equality is guaranteed through various fundamental rights between Article 14 and 18. We all know Article 14 to 18, right to equality. Affirmative actions are designed as pathways towards goal of equality. This is also correct. Affirmative actions means reservations, etc., to get the people who has been experiencing wrongs in their history to a particular level. Okay, so that's called affirmative action. For example, reservations. So all the three statements are correct. Cultural and education rights. What are cultural and education rights? Article 29 and Article 30. So these rights are meant to protect the interest of minorities and to enable them to establish educational institutions. This is Article 30. So this is right. The Constitution clearly defines minorities? No. Constitution does not define minority. Okay, minority is defined in somewhere else. Just let me check. So I guess National Commission on Minorities defines minorities. Okay. The Constitution recognizes two types of minorities, linguistic and religious. This is also right. Linguistic and religious minorities. Constitution recognizes two types of minorities. The unit for determining linguistic and religious minorities shall be state or union territory. This is also correct. Okay. Three statements are correct. Principle of natural justice ensure that no person shall be punished without fair hearing. Of course, that is the principle of natural justice. You can, by logic, you can say that this is the correct statement. The expression natural justice is defined in the Constitution. No, this is not defined. Article 32 of the Indian Constitution provides constitutional remedies against the violation of principle of natural justice. You can say so because fundamental rights are dependent on natural justice. So if fundamental rights are violated, you can go into Supreme Court. So that is also right. Basic structure. The basic structure doctrine was introduced by Supreme Court in the Golaknath versus State of Punjab. No, it was in response to this case in Keshav Bharati. So this is wrong. It falls outside the scope of amending powers of Parliament. Yes, Parliament cannot amend the basic structure. The Supreme Court mentioned in clear terms the constitution of this doctrine in the Keshav Bharati case. Now this statement is wrong because Constitution just mentions Keshav basic structure doctrine. It does not give the constituents. What it constitutes, it does not give. Just mentions. Okay. What it constitutes is given in further judgments of the Supreme Court. Okay. So only one statement is correct. Article 12. What is state? Okay, so I have already told you what is state. Union government, yes. Union parliament, yes. Panchayat, yes. Municipality, yes. Judiciary, no. So 4. Right to equality in the part 3 of the Indian Constitution. Now if we go to right to equality, part 3 means fundamental rights. It guarantees that no citizen shall be treated unfavorably by the state when compared to others only because of race, religion, caste, sex, place of birth. Okay, so right to equality in part 3 of the constitution. What is right to equality? From 14 to 18. So guarantee that no citizen shall be treated unfavorably by the state when compared to others only because of race, religion, caste, sex, place of birth. So this is applicable for article 15, right against discrimination. This part prohibits discrimination only by the state, not by private individuals. This is wrong. Okay, discrimination of private individuals is also considered as it is also prohibited. Okay. So no citizen shall be treated unfavorably by the state when compared to others only because of race, religion, caste, sex. As we all know, there are few articles here which are available for all the persons, not only citizens. Okay. So basically, if we consider here only article 14 of the constitution, which types about right to equality, then these conditions will not take place. This is only applicable for article 15. Okay, so this is also wrong. With reference to fundamental rights enshrined in the constitution, political equality signifies. What is political equality? Providing every citizen the right to vote and right to get elected. Yes, we can say that it is a political equality. Providing special provisions for socially and educationally backward classes, scheduled castes, scheduled tribes. This is social equality. This is not political equality. Granting equal citizenship to all members of the state with basic rights. Yes. Bridging inequalities in income activities. No, this is again a socio-economic. Okay. So confusion will be between these two. Now, what do you think is a more overall or a more comprehensive statement? That will be the answer. Answer is C. Granting equal citizenship to all the members of the state with basic rights. Consider the following statements about rights provided under Article 19. These 6 rights are protected only against state action and not against private individuals. Now, I have already said that Supreme Court judgment have given that now Article 19 will be applicable horizontally as well as vertically. Vertically means against the state, horizontally against the private individuals. So this is wrong. Now it is applicable against private individuals also. These rights are applicable to both citizens and foreigners. No, this is only applicable to citizens. Article 19. These rights can be suspended when national emergency is declared on any grounds. Now emergency we have not done, but still you should be knowing that under national emergency, Article 19 will get suspended automatically only if national emergency is because of first war or external aggression. If this is the reason for national emergency, then Article 19 will get automatically suspended. So not on all the grounds. So this is saying any grounds. So this is also wrong. Constitutional guarantees protection against arbitrary and excessive punishment to all persons. This is regarding Article 20. Okay. Both civil and criminal laws can have retrospective effect, and I have already told you in Article 20. Retrospective effect can only be applicable to civil, not criminal. Okay. Criminal laws cannot be retrospective. Okay. For example, if a crime is for example, stealing is not crime in 1920, and you are getting in an act today to prove that stealing is a crime, you cannot punish a person far back on that law. Okay? So the retrospective effect is only for civil, not for criminal. So this is wrong. For a same offence, a person cannot be punished more than once. This is what is called as no double jeopardy. This is right. No person accused of any offence shall be compelled to be witnessed against himself or herself. This is also correct. That is no self-incrimination. Justice. Equal treatment of equals is considered as one of the crucial aspects of justice. Political justice includes just distribution of goods, services, and the recognition of the special needs of certain groups in the society. A just society is the one which there are no inequalities between certain sections and absolutely no difference between the rich and the poor. social justice in the Indian constitution is provided only in the directive principle of state policy. So this is wrong. Social justice is given in fundamental rights also. Equal treatment of equals is considered one of the crucial aspects of justice. No, there are situations where equals and unequals are treated differently. Political justice includes distribution of goods and services. So this is again a social justice. This is distribution of goods and services is a social justice. A just society is the one in which there are no inequalities between certain sections and absolutely no differences between rich and the poor. That can be called a just society. Okay. So if we consider this, equal treatment for equals is considered one of the crucial aspects of justice. This is talking about the second part of Article 14, that is equal protection of law. Equal protection of law. So equal treatment of equals and unequal treatment of people who are not equals. Okay, so that is the one of the aspect of justice. So this can be correct. So this is not correct and this is not correct. So confusion is between this and this. A just society is the one in which there are no inequalities between certain sections and absolutely no differences between the rich and poor. So this seems to be a more extreme statement. We can settle for A. So these are not the question that will come in the exam. This is just for your practice. Okay. Protection in the respect of conviction, as mentioned in Article 20, it prohibits retrospective criminal legislation. Yes, no criminal legislation can be retrospective. This is correct. The immunity and self-incrimination witness extends to civil proceedings. Again, self-incrimination witness extends only to criminal, not to civil. Okay. So self-incrimination means witness against himself can be applicable only in criminal cases. Not immunity from self-incrimination is applicable only to criminal cases, not to civil. So C. Theory of fundamental rights implies sovereignty of people, equality of opportunity for all, equality of all before law, and limited government. Now, as we all know, fundamental rights are negative in character. They put some restrictions on the state against the individual. Okay. So what the fundamental rights are doing? They are limiting the government. So limited government is the answer. Their fundamental rights are negative in character. They are putting pressure, limitations on the government. So it's a limited government. This question has been repeated almost 3 times in last 5 years. Which of the following statements with respect to fundamental rights of freedom of assembly in the constitution? The right is available to both citizens and aliens. Now freedom of assembly comes under Article 19B. So Article 19 anyways is not applicable to aliens, means not citizens. So this is wrong. Right includes both the right to assemble and right to strike. No, right to strike is not available under this. Right to strike is available in a legal right, which is by statute, not by constitution. So this is also wrong. This right is absolute in nature. Of course not. There are certain conditions for assembly, that you should not hamper the public order. Okay? Public order, public safety, etc. There are few conditions here. You can check in the constitution. The state can place reasonable restrictions on this right on the ground of public order. Yes, this is the one of the restrictions, public order. So the reason that it is not absolute in nature is because of this. Consider the following statements with reference to the right to freedom of religion. Right to freedom of religion. 25-28. They cover only religious beliefs but not religious practices and rituals. Actually, they cover both. Okay? No religious instruction shall be provided in any educational institutions administered by the state. Now, I have already told you, administered by state is not the condition. Fully aided by state, that is the condition, that no religious instruction shall be provided. So this is wrong. So we have completed fundamental rights. So I was hoping to complete DPSP also today, but I think it will not be possible. So the basic thing regarding fundamental right is you should be aware of each and every right as per the language in the constitution, because there are many questions asked in this area directly copy pasted from the constitution and put it under the options. Okay, so you should be able to recognize what is given and what is not. Okay, so the main thing under fundamental rights is that you should be reading from the constitution all the rights from 12 to 35, all the rights should be read out. Okay, so anything else in fundamental rights? Let me check. Okay, so one thing is there, for example, we can do it in next class also, fundamental. Okay, just a second. Now, since we have seen the amendability, we will see the 368 article also. Okay, article 368, which is called for amendment of the constitution. Amendment of constitution. So we can deal with it now. So what article 368 says, that constitution, it basically gives the procedure for constitution amendment. So what is the procedure? A bill for constitutional amendment can be introduced by both private member or government member. That's not a problem. It can be introduced in any house, Lok Sabha or Rajya Sabha, by private member or by government. This is also possible, and it is introduced in any house. Does not require president recommendation. It does not require president recommendation. Okay. Now, Lok Sabha, if it is introduced, it has to be passed by special majority. Then it will go to next house, for example Rajya Sabha, again passed by special majority. Then it will go to president action. If amendment of the constitution is regarding certain provisions which will hamper the federal structure of the constitution, means relation between state and the center, then after getting passed from the parliament, it shall go to states, and at least half of the states shall approve it by simple majority. Okay, half of the states shall approve it by simple majority. Then it go to president. President has no choice but to give his assent. Okay, so basically this thing that president has no choice. Previously president had a choice to recommend it back, but now president has no choice, and that was under Article 24th Amendment Act 368(3). Sorry, president role in 368. President cannot send the bill back; he has to give his assent. And further, 368(3) again state that Article 13 does not apply. Article 13 does not apply, means this 24th Amendment Act, it re-ensured that constitutional amendment will not be called as a law. For example, it added in Article 13 that under 368 amendment under 368 will not be called a law, and under 368(3) it said Article 13 will not be applicable here. Okay, that means 368 amendment under 368 will not be applicable as a law. So these are the two things that the 24th Amendment Act came up with, and further president's role, limited the president's role. Now, by applying this, it made sure that this will not be taken as a law and there shall be no judicial review. But since the Keshav Bharati case clearly stated that there is only a basic structure which is important and not anything else. So now amendment in constitution, now since we are in amendment, we can say that amendment in constitution. amendments in constitution are done by three ways. First, simple. So amendment is done by three ways. First, by simple majority. Yes, there are few things which can be done. Constitution can be amended by simple majority. Second, by special majority. And third, by special majority plus ratification of states. Okay. So there are three ways of amendment of the constitution. So these two ways are under Article 368. This amendment is not under Article 368. This is normal law. Okay. So what is involved in this? Special majority plus ratification of state. What will be included? First, election to president. If any amendment has to be done regarding election of president, it has to be passed by special majority in parliament as well as the ratification of the states. Then extension of executive power. Extension of executive power of union, because that power may extend into state, so that is also one thing. Then Supreme Court, High Court related issues that are also included in this. Then fourth is Schedule 7. Schedule 7 means which gives the list of union list, federal list, union list, state list and concurrent list. If any amendment has to be done in this, it has to be ratified by the state. Then anything regarding GST Council. We know GST Council has been brought in constitution recently. Sixth, Article 368 itself. Okay. So if any amendment has to be done in Article 368, it has to be ratified by the states. And representation in Rajya Sabha. Rajya Sabha representation. If there has to be change in Rajya Sabha representation from any state, then has to be ratified by the state. Special majority, only special majority, no ratification of state. Fundamental rights, DPSP, etc. These are the two main things which are amended by special majority, no need to go to states. And then here we come across for simple majority, we can, for example, Article 2, Article 3, that is regarding union and states, naming of state, naming of changing the name, changing the area, etc., union and territory. Then comes Schedule 2, I guess. Schedule 2. Schedule 5 and 6. Schedule 5, that is schedule areas. Schedule 6, tribal areas. All these schedules, if amendment has to be done by simple majority, no need to go to special majority. Then election of Lok Sabha, Rajya Sabha or MLAs. That procedure also can be changed without going to states. Then use of official language. This is also a thing that can be changed without special majority. Then regarding citizenship or delimitation. Then regarding UTs. Okay, so there are a few things that can be amended, that need not require 368 to be amended. Okay, so these are the things that I need to mention. I think we will stop here today and we will see DPSP in the next class. So since you have more time, 16 June is the new date, you should not be in relaxed mode, you should be in hyper mode now. Okay, so thank you, I will stop here.